Welcome back to Real Estate 101. Today we're going to continue our discussion on education law and talk a little bit about school expulsions and suspensions. And I'm pleased to be joined once again by John Schumann of Devery Smith Frank. John, welcome back to the show.
Great to be back, Joe.
All right, John. So if you think your child has been suspended or expelled from school unfairly, is there anything you can do?
Yeah, if you're in a public school board, there's a lot of stuff you can do, and there's a lot of rules and procedures in place for dealing with that. If you're in a private school setting, then it really depends on your contract. And what the part that usually governs this is the code of conduct that is incorporated into your contract with the school, but it's all completely governed by your contract with the school. If it's not in your contract with the school, then there may be things a bit more complicated you can do, but basically it's the law of contract.
Okay, so how is it different for public schools?
Well, every child in Ontario who's of school age has a right to attend a publicly funded education institution, and that's not a right that can be taken away easily. So to kick someone out of school but through suspension or expulsion, that's taking away that right, and it can't be done lightly. So the things that you have to do to get suspended are fairly serious things. They are things like, threatening to hurt somebody, being intoxicated at school, having drugs or alcohol at school, bullying. Yeah, and are there like really serious behavior issues? And even then, what you do as a student you have to do it at school or at a school-related activity. And before a principal can suspend you, they have to consider whether there's any mitigating circumstances. Mitigating circumstances are things like the child's age. Are they too young to realize what they did was wrong? Are there special needs that affect the child that the school's not dealing with, and that's the reason why the child acted out or didn't act properly? Is this a result of the student being harassed? Is it a response to some bad behavior that the student's finally broken down and acted out badly? If that's the case, then that mitigates against the child being suspended or expelled. And there's other considerations, like did the school try to do anything before suspending or expelling? Has there been any progressive discipline? And a number of other things that mitigate whether or not the seriousness of the situation and whether a child should be expelled. And even then, after you've done that, a principal decides to suspend, even then the parents and the student, when they're older, have a right to appeal that suspension to the board and have a hearing about whether the child should be suspended, because going to school is a right in Ontario.
All right, John, so what about expulsions?
So there are two kinds of expulsions, either from the school or from the board. Now, from the school means the student can only go back to the same school. From the board means the student's not allowed to attend schools, normal schools anywhere within the board. Now, these are both very, very serious punishments, and they are only applied in the most serious of circumstances. And when we're talking serious, we're talking like criminal-type circumstances. So we're talking about assaulting people, physically assaulting, sexually assaulting. We're talking about repeated bullying. We're talking about hate crimes. We're talking about that level of seriousness before a student can be expelled. And even then, a principal does not have the power to expel a student. Only the Board of Trustees has the power to expel a student. So before a student can be expelled, there has to be a meeting of the Board of Trustees with the parents and a hearing at the Board of Trustees to decide whether the student should be expelled, unless the parents agree to waive the right to an expulsion hearing. And there's no reason why parents should waive the right to an expulsion hearing without speaking to a lawyer first. Because I said these are only the most serious circumstances when expulsions should apply. And again, the principal and the board are required to consider mitigating circumstances first. So if any of those same mitigating factors apply, then the student should not be expelled. So it's always worthwhile to speak to a lawyer before you agree to an expulsion.
All right, but aren't kids who are kicked out of school or expelled from school automatically kicked out?
Well, they're out of school right away, because what happens first is that a principal suspends the student for 20 days. They give the student a notice that they're being suspended pending expulsion. And that 20-day period is a period when the principal does his investigation, passes it on to the board gets ready to do the hearing, and they organize the hearing. But that's only 20 days when the student is out of school, and in that 20 days, a decision has to be made about whether the student is going to be expelled, just suspended, or allowed to return to class. And that part is like a temporary measure until the final decision is made.
All right, so what are these hearings like?
So at the board level, they look very much like a trial in court, except it's not in a court, it's in the board offices, and it can be before the Board of Trustees in the board meeting chamber. But there's a group of trustees who hear the board, so they sit like judges, and a principal is there to present the case for expulsion. Often the principal has a lawyer. Sometimes the board has a lawyer to help them make sure they get all the law right when they're doing this. and the parents are there at the other table, and they can have a lawyer if they choose, and they call witnesses, present their case, and then the board, after they present their case, makes a decision about whether the student should be expelled or not, or whether a less serious punishment is more warranted.
All right, so what can the board do at the end of the hearing?
So again, the board can decide to expel a student from the entire board. They can decide to expel a student only from the school from which they were previously attending. They can decide that a suspension is appropriate instead. And that suspension can be less than the 20 days the student's been out for. So all that goes on the record maybe is a 5-day suspension as opposed to up to a 20-day suspension until the hearing was held. Or the board can decide that no punishment was appropriate. Maybe the principal got everything wrong. Maybe they didn't know what was going on at the time the original decision was made, and now it's clear that it's not appropriate to impose any punishment. And so the board can pick any one of those things, and that's what ends up being on the student's record.
All right, so if a student is expelled from school, does that mean they've lost their right to go to any school?
Well, it means they've lost the right to go to any, basically normal school, but boards are required to offer programs for expelled students. So there are often special schools that are with programs designed just for expelled students, and there's programs that have an education component. They also usually have social workers and psychologists and things to help, because these are rehabilitative type programs in addition to having an education component. But that student's not going to go back to a normal classroom. They're going to be in a special, therapeutic, secure type classroom.
Right. Okay, so what about if the parents or the student disagrees with the board's decision?
So there is a right of appeal from the board's decision, and that appeal is to the Child and Family Services Review Board. The Child and Family Services Review Board is a tribunal of sort of experts in education and other children's issues that's put together by the Government of Ontario, and all they do is hear appeals with regard to school boards and children's aid societies, and they're sort of experts on the law and the area and what goes on in schools. And that hearing looks almost exactly like a trial. It happens in a hearing room. If it's in Toronto, it's in an actual hearing room that looks a lot like a courtroom. There's witnesses again. These hearings can go on for a long period of time because you're entitled to present your entire case, call as many witnesses you want, call expert witnesses, do whatever you need to present your case. And there's arguments before and afterwards as to what should happen. There can be motions. It's exactly like a court proceeding, but these are a bit more sort of focused experts on the area of education than would be judges. And that after that hearing, the Child and Family Services Review Board can decide to uphold the expulsion, or can decide that there should be no expulsion, and that another punishment was more appropriate than an expulsion, and return the student back to the school.
All right, so does the record of suspension or expulsion, does that remain on the student's record?
Well, it does go into the OSR, which is the Ontario School Record, and the Ontario School Record travels with the student as they go through their primary and secondary school education. So it's always with them until they finish high school.
Right.
But what's in there is subject to review by a principal. So it is possible to apply to a principal to say, my son was suspended in grade 1, he's now in grade 11, I want it taken out. It's no longer appropriate for it to be there. Or there's other reasons why it might be inappropriate for the child for it no longer to be there. Maybe the students changed their behavior, or things have changed dramatically for the student, and now we recognize it's no longer appropriate. The principal has the discretion to take things out of the OSR if they're no longer appropriate. Some boards have specific procedures for doing that, and if you ask to do it, then they'll tell you what the procedures are. Some of them are more formal than others. But there are also rules that say that for things like violent offenses or more serious behaviors, that for violent offenses, the record has to stay in for at least 5 years, and for other offenses, it can be 3 years before a principal can even consider taking it out. And so it is something that can go with the student for a long time, and it is something that can stay in their record when they're applying to university or college, and it is something that some universities and colleges ask about.
All right, so let's say the principal can't meet the legal test to get a student expelled from school. Is there something they can do?
No, not for a behavioral problem. There's nothing else a principal can do to get a student out of a school. The only other way to get a student out of their home school, because students are allowed to attend their home school, the one that's in their community, that's closest to them, that has the easy access for them. The only way to get a student out of their home school is to find that they have special needs that home school cannot accommodate, and have the school board move that student to another school. But that involves doing what's called an IPRC, which is identification and placement process. And that identifies students having special needs and says that student needs a special type of classroom that the home school cannot provide. And when the board parents are involved in that, they get to go to the IPRC to decide or to assist in deciding whether their student should be moved to another school or what program is most appropriate for their child's special needs. And if there is no identification or set placement that's outside the school and no transportation provided, then the student cannot be removed from the school. Some principals try to do this other thing called an exclusion, which is basically giving a trespass notice to a student to say, you're not being expelled, but we're not allowing you to come back to the school because there's a safety concern or some other sort of concern that you might be injurious to the moral tone of the school.
Right.
But you cannot exclude a student who is enrolled in a school. So a principal cannot give you a student a trespass notice or an exclusion notice from the school to which they're enrolled, at least not a publicly funded school. And so that is not a mechanism that's available. And if a principal tries to do that, see a lawyer because it's absolutely illegal under the Education Act regulations.
All right, John. So what should parents know if their child gets into serious trouble at school?
Well, they should look into what happened and find out what happened, and they should speak to a lawyer probably to find out what the mitigating circumstances were, if there were any mitigating circumstances that were missed. The parents are allowed to get disclosure from the school to find out what the entire investigation was and what all the cases against their student. And that is, they can do that on their own, and they can ask for it on their own, but they might have get it more easily with a lawyer. And then they can decide what they're going to do, whether they're going to challenge the suspension or challenge the expulsion, both of which they have an absolute right to do. And it's just up to them whether they feel it's worthwhile or not. But unless you speak to a lawyer, you're not going to know whether you have a chance or not and whether it is a good idea or not to challenge the suspension or expulsion.
All right, John, for anybody watching and listening who may want to get in touch, how can they reach you?
Well, they can reach me at our website, which is www.debrylaw.ca. They can phone me at 416-446-5080. They can email me at john.schuman@debrylaw.ca. They can follow me on Twitter at SchumanFamLaw, and they can find my Facebook page.
All right, John, great stuff. Thanks for coming on today's show.
Thanks for having me, Joe.
So there you have it. If you're looking for more information on education law, get in contact with John Schuman at Devery Smith Frank. Don't forget to subscribe to our YouTube channel, like, comment, and share our videos. I'm Joe. Thanks for watching, and we'll see you next time.